It's like really slowing down my homework.
Okay, I think this is on now. Okay. All right, so good timing, good timing. So we were just looking at what we're doing is taking a look at some questions from the final exam, and we're using it, one, to sort of foreshadow what you can expect, and then also using it as a way to review the material, okay? And what I noted before is that when we get to next week and the following week, we'll be talking about motions practice. And so a lot of this stuff will be the basis of our motions. So we want to make sure we have this sort of these foundational concepts. Our first question was dealing with the issue of jurisdiction. And we had noted that courts must have two types. And so we're just sort of generally outlining our material real quick, okay? So personal jurisdiction and subject matter jurisdiction. Personal jurisdiction, we said, was what?
Yeah, it's you have to establish a residence, right?
It's the court's authority to exercise power over the person.
Right, so this is the court's authority over the person, okay? And then subject matter relates to the court's authority over the topic, exactly, the case itself, okay? So then we're looking at how do we establish personal jurisdiction? So of course, if we live there, then it's reasonable, right? The court can establish personal jurisdiction over you. Then the question became, okay, well, what if we have a non-resident defendant? What's that statute that we're going to use? The long-arm statute, okay? So then we have this concept. Long-arm statute, okay? And then under this, court can exercise, I'm going to erase this for just a moment.
I don't like your pen.
Excuse me. Exercise
Well, you like
jurisdiction over non-resident defendant if we can show, what's that phrase? If we can show, and I'll give you the first two letters, MC. That's right, she's on a hot roll. She said minimum contacts. Okay? We can show minimum contacts. And those minimum contacts can be established if we can show, for example, that they came, they got busy, had a baby, they had an executed contract, they transacted some sort of business, they committed a tort. You with me? All right. Is this okay? Did I lose anyone? Everybody okay with this? Okay. Now, why did we say, what constitutional provisions did we say were at play here in terms of making sure that it was appropriate for the court to do this? We said that it's so important that it's mentioned under two different constitutional amendments. This concept of what? Yep, it's mentioned under the 5th and 14th. And what is mentioned under the 5th and 14th? It's so important. Due process, right? Because we want to make sure that people are on reasonable notice, hey, that you could be subjected to the court's jurisdiction. So this is why we have to make sure that there's some way of establishing they have minimum contacts. Well, through these minimum contacts, the court says, okay, well, you were on reasonable notice, right? So we said due process means two things. Due process. So 5th and 14th Amendments. And what do we say due process means? I said one without the other is completely meaningless. You've got to have both. I have notice and what? An opportunity to be heard. You okay with this? All right. Now, what do we say about personal jurisdiction in terms of how that objection might be missed or waived potentially? That's right. I can consent to personal jurisdiction. Can I waive it too? Like if I forget to, right. So when do I have to raise the issue of personal jurisdiction? Can I wait and bring it up at trial? When should I address this issue of personal jurisdiction? I better address it when I file my response. It should be in my initial response to pleadings. Okay with that? All right. So then we got to the idea of, subject matter jurisdiction. Okay? This is the court's authority over the particular case type or subject. Can I waive subject matter jurisdiction? Well, why not? I can waive personal jurisdiction.
It's about what the case is going on, what's happening.
So remember, it's one thing for me to say, court, I give you permission to hear this case as it relates to me, my body, right? For you to exercise jurisdiction over me. It's another thing for me to say, court, now I know you don't normally hear this type of case, but I'm going to give you permission, right? It's a little bit different, right? So you understand why we can't give the court permission over subject matter?
Yeah.
All right, this is also going to be set by statute. So along those lines, in terms of talking about subject matter jurisdiction, that's where we kind of got to the idea of the chart here and diagram the different jurisdictions that the courts have. Okay. All right. So all of that is a backdrop to this right here. Okay. So we have jurisdiction of the person, we have subject matter jurisdiction, and then we spoke about the idea of jurisdiction emanating from the property.
That's
okay?
the term I was thinking of when I said restitution.
All right. So when we have that, usually we'll see this in realm. Okay. Or sometimes you'll see quasi in realm. Okay. All right. So let's go back to our question here. We got Jack and Sarah, they're both residents of Iowa. Let me just pause this. Do you understand how we just compacted this, we unpacked this question here? So that's all the foundational stuff you have to know and appreciate in order to be able to answer this question. All right, Jack and Sarah are both residents in Iowa. All right, so they're residents of Iowa. They have a dispute regarding some land located in Texas, okay? So land is in Texas. Jack files a lawsuit in Iowa regarding the land. And John objects, claiming that Iowa courts have no jurisdiction. In this case, the Iowa court can hear the case? What do you think? No? Why not? Do they have personal jurisdiction?
Yes.
Yes.
Do they have subject matter jurisdiction?
Yes. Well, their personal jurisdiction is not their section.
All right, let's keep going. The Texas court has in realm jurisdiction to adjudicate the claim regarding the property. Is the issue located? Where's the land located at?
Texas.
In Texas. All right, let's keep going. The Texas Federal District Court can hear the case based on diversity of citizenship.
But doesn't the two parties have to be the diversity of them, not the property?
So there's a lot more here. So diversity jurisdiction is what? What do we mean when we say diversity jurisdiction?
It's like looking at two different states.
But this relates to federal.
Yes.
Establishing federal jurisdiction, right? This is our basis for getting into federal court. And we need two parties from different states, and we also need what? Amount of controversy, right?
Yes.
Exactly. So do we even have enough information for this? And so we know it's not this one.
If it's 75,000, that's going to be the federal district court, right?
What now?
Let's just say that.
But what else? What else? What else are we missing here? Where are they both from? This is never going to be in federal court. Because they're both of the same. Is that okay? Does everybody get that? Okay. All right. The Iowa court has in realm jurisdiction to adjudicate the claim regarding the property.
No, that's Texas.
So where is the best place?
Iowa.
Which one? Huh?
I mean, I'd say B because. Yeah. Okay, we were right. AB.
Which one is the most clear?
T.
B.
Actually,
Yeah.
Huh?
I mean, they both seem pretty clear, you know.
So in this case, which one? So you don't have the options here when you look at this whatever where it says like choose like a whatever on canvas.
It's a distinct
Yeah.
one. It's
Yeah.
B.
So we could do A. So if we said A, this is going to be what? Based upon what? Personal jurisdiction. If we do B,
It's rent.
what?
Positive rent.
It's going to be on the rent.
Yeah.
Exactly. Okay. So these are sort of the things that are going to pick that we're sort of kind of going to be picking through. Are you guys okay with this?
Yes.
All right.
It's B.
Yeah.
Okay.
So I didn't show you the top part or whatever. What you're going to do is pick out when you get to the final exam, right? You're going to have multiple choice answers here, and so this is going to be A and B. With me?
Oh,
So you could put A and B?
Yes.
A and B, okay.
With an explanation point. So your exam is going to be multiple choice, true, false, and you're going to have an explanation point here. Okay.
okay.
All right. Let's see here. But remember. But look at the question though. He says he's claiming that the Iowa courts have no jurisdiction. Do the Iowa courts have any jurisdiction?
Yes.
Both
They have
residents.
personal jurisdiction.
Huh?
Yes.
Don't they have personal jurisdiction?
They're both residents.
They're both residents of Iowa.
So the
Okay.
Iowa.
What else? What else? Hmm?
He's playing.
Boston.
John is claiming the courts of jurisdiction. Why is he wrong? Because they both are residents.
But which one is going to be your better answer?
B.
B.
But which one is better? I know we said A, I know we're you guys are looking at A and B, but I want you to. What's going to be your best answer?
B.
Does everybody agree that B is going to be your best answer?
Yeah.
Do you know why? Do you see why?
Because the
property is
property's
in Texas.
Yeah,
Yeah.
exactly.
Does that make sense?
Yeah, oh yeah.
And the dispute is over the property.
Yeah.
Okay, I just want to make sure that we're clear because
Yeah.
So
so
if it
yes.
was a true, false, we would have put true that we're answering he was objecting.
So in this case, does the Texas court have the Texas court has interim jurisdiction to adjudicate the claim regarding the property?
True.
Okay.
Yes.
The Iowa court, can they hear the case?
Yeah, if they want, but why?
So where you're getting stuck at is remember, here's
Here's waive subject matter.
exactly.
Okay, that's why.
Why does Iowa? Why, so here's the thing. I don't want you to forget the concept. What we just talked about, and I know I'm trying to confuse you here, but what I want you to really emphasize is you have to have two types of jurisdiction. You with me?
Yeah.
So yes, you're right. A is good. A is good in some sense. If we were only looking at the issue of personal jurisdiction. But personal jurisdiction itself is not enough. Tell me what gives the Iowa court authority over this property that's located in Texas?
Yeah, they don't.
You with me? Okay.
What confused me is you said the true, false things, and then we're gonna
Yeah,
have like an
because
explanation
you
thing. So that was like, so we would
subject
answer
matter.
that how true, false. Then.
Okay.
Yeah, because when you look at your exam so what I'm toying with is like if you give me A, you better explain what you mean by here. So if you were to do this and say, yeah, personal jurisdiction,
But it's,
right? But no subject matter, then I'm probably going to give you credit. But what I'm really hoping you're going to do is point to B. Because
Yeah.
B is the most correct answer because
Yeah.
Texas does have in-realm jurisdiction over this case
Because of the property.
because of the property.
The subject, okay, gotcha.
Does that make sense?
Yes. makes
All
perfect
right.
sense.
And that's why we're going to go through each of these questions. This will take a little bit of time, but I want to go through and unpack all this that we need to understand behind the question, and then that'll make sure that you really get it, okay?
Sounds good.
All right, let's see here. Now let's look at question number 2. In 2013, the plaintiff Jackson was involved in a vehicle accident with defendant Hope. Trial is scheduled to take place in November 2014. Jack is seeking damages for costs associated with medical bills and the repair of his car after Hulk ran the red light and crashed into him. Which of the following statements are true as to what would be admissible under the rules of evidence? You guys don't even remember that we talked about the rules of evidence.
Oh yeah, that was
I know.
Take a minute.
okay. Notes.
what would
Oh
be
my
admissible?
Rules of that, oh my gosh.
I know.
That
Feels
was a while ago.
I know.
Feels like last quarter.
And all I can think is hope.
So you want to know these are evidence? Obviously.
No, and that's what I want to point out to you. See how there's this hyperlink here? Right? So you can use your court rules. Remember, the rules of evidence are also going to be in your court rules
But you're
book.
not putting down like the wrong
But
evidence
additionally,
rule.
though, you can click under the rule. What do you mean am I not putting on the
No,
wrong
like,
rule?
okay,
Am
I've
I
had some
putting the wrong
exams, no,
rule?
I've had some exams where it would say like, okay, for ER 609, and then it would have the wrong explanation of what that evidence rule is, and you would have to then know kind of that.
Okay,
So,
so I'm not going there. That's a little bit too complicated for my simple brain. So,
just making sure.
no.
We're not gonna try to do this tricky stuff, it's just.
So let me get everyone's attention, okay? Because I want to explain this because I think what Courtney is saying is kind of complicated. So I want to simplify this, okay? And I want to make sure you understand what I'm doing. So what I've done here is when you pull this exam up, this right here, this like hyperlink to that rule. You with me? So you can click on the rule and read the rule and see if that is going to be appropriate. Now this, just because it's here doesn't mean this is correct. That's what you have to decide. You with me? All right, so under ER 609, evidence of the plaintiff's 2004 assault in a third degree conviction would be admissible. So we have to understand what does ER 609 relate to?
Past history or?
So ER 609 relates to what? What kind of history? My sexual history, my criminal history? Ah, all right. So criminal history, specifically crimes of dishonesty. Okay? And there's some language in there about like if it's a crime of dishonesty, then that can be used to impeach or question the witness's credibility and so forth. So long as it had a penalty associated with at least a year, and is it within 10 years?
Within the past 10 years, right?
If it's within the past 10 years. So here's the thing, under EO 609, can we get the 2004 assault in a third degree conviction?
Yeah.
Based upon what I just explained to you about the rule. Can we get that in there?
Yes.
Why?
10 years, right?
Involved in a vehicle
Remember, crimes of dishonesty.
Oh, yeah.
What's an assault? Unfortunately, I can kick your ass, but that's not a crime of dishonesty.
No, it's not.
Now, if I lie about it, I get a false statement, okay, with me?
Yeah.
Are we okay with this?
So it's only
All right,
against the law.
so we're gonna cross this one out. Did I lose anyone? I really want to make sure that we have an opportunity to flush these questions out. I'm not gonna change this. So as we go through here, and you feel like, wait a minute, I think that that's a little bit tricky. Like, let's talk about it, because I don't want to trick you. Okay? All right. So under ER 701, the bartender of 10 years would be able to provide a lay opinion as to his perception that the defendant was intoxicated upon leaving the bar the night of the accident. But what's ER 701? Opinion testimony. And what does it say about opinion testimony? Can we offer opinion testimony by a lay witness?
Yes, based upon your experience and facts, or that based on skill they observe.
10 years.
Okay, so we're thinking that so I'm gonna put an arrow just like I did for the, so we're thinking maybe that one. All right, let's go through and flush out the other ones, okay? All right, under ER 402, evidence that the plaintiff had an abortion would likely be admissible. Okay, but what's ER 402?
It's, if it's relevant, then it's
Relevant.
and I don't think it's relevant.
Okay, all right. So do we agree with that? Under ER 402, remember what are we talking about? Car, vehicle accident.
I'm starting off with that.
We okay? So we're gonna rule this one out? What do you think?
Wait, okay, next
Yeah.
question. Just because I know this is making it more complicated, is she
No.
actually on her way back from just now getting the abortion? Or is it like, that's just the past thing?
Oh, she went deep on that one, didn't she?
Oh, and just asking, no, because then it would come into play, was she on medication? You're not supposed to do that after an abortion.
Okay. So
I'm just sorry, I'm making it more complicated, it was just one of those, just trying to talk to my
Okay,
head.
so let's take it on its face. Okay. So let's assume that this is prior to that.
Okay,
All
since it
right.
didn't say in the past, it just said.
No, but here's the other thing though, okay? Take it on its face.
I did
I think
too much,
that's
I'm
a
sorry.
little bit, I think that's a far stretch to read into
Okay.
the question though, okay?
That's okay.
No, it's okay. But if you do that on another type of exam, that's gonna mess you up. Just
Yeah.
read the question. All right. You definitely want to take. You don't want to take that approach on a bar exam or on your pacer exam. Okay? So but think about it. Well, let's hold up. Under ER 402, evidence that the plaintiff had an abortion would likely be admissible. Absent any additional facts, it's probably likely not going to be admissible. Does everybody understand that? Okay. All right. Under ER 803, A6, the lab report of the expert unable to appear personally would be inadmissible as a business record.
It's not a
Hey,
business
is
record.
that a
though,
B
right?
or 6? Because we have like a business record.
A6. It's a 6.
Well, we don't have a 6. We
The
have
lab
B.
reports aren't business records, are they? Lab reports, they're not business records, are they?
Is it under that one?
Yeah.
So it would be.
Like, I'm looking at.
So the whole inadmissible thing is.
Oh, here we
And
go.
it says
Five,
ER
six.
803
Business
AB. So I wonder if that's supposed to be.
So it's A6.
It's gotta be a 6, so there's a typo somewhere.
Yeah.
Record trigger.
So we're in the 8, and then A, and then 1, 2, 3, 4, 5, 6.
Oh, we don't have.
Records are
Can
regularly
we go back up
conducted.
to this?
Yeah, back up this one.
Yeah. Your state.
What are you saying? No, that's not it.
So now I'm gonna flashback, okay?
Yeah.
Okay.
Oops. Where's it at? What did I do?
Oh, you closed it. Okay.
Did I close it?
Oh, you closed it.
You clicked on the thing, did it
Wait, you
disappear?
have a Chrome too.
Is it Chrome?
Or Internet Explorer.
It's a Word document. Where's my Word document?
Yeah.
Okay, let's do it again. Maybe it closed it, okay.
So are we gonna do the final exam to Canvas?
What now?
Are we gonna do final exam on Canvas?
I can't understand your question.
The
Are we
final
gonna do what?
exam, are we gonna do it in Canvas or in class?
We're gonna have.
You're gonna do it in class, and then you're gonna pull it up on the canvas, and you're gonna read it. You have a Scantron for this portion, and then you'll be able to type and upload your
But
response.
she did say it's still open book.
Okay.
Yeah, we still use our notes.
You can't talk to each other. Do black quizzes.
Yeah.
I don't know if that would help me much anyway.
Okay, so we're.
Okay. So is this true right here?
Yeah.
Yeah, that's true.
No, this is not
that's
true.
not true.
This is
Oh.
not true. Okay.
B is possible, yeah.
Is this true right here?
No.
No, no. E is no.
Is this true right here?
Yes.
Yeah,
B.
I think so. E is.
Is this under 701?
Yeah.
Is it lay or is it expert?
Lay.
I think it's expert.
Is 701 is it lay witness or expert witnesses?
He's skilled, she's skilled.
That's their job,
Yeah.
to know if someone's sort of.
What is 701? Is someone regarding expert witness or is
Lay
it?
witness.
A skilled layover.
So that wouldn't be.
Wait,
right
hold
then.
on, you guys. I keep losing our final exam. Let me just download this so that I can, so I don't.
We just print out a bunch of copies.
Yeah, you can print me out a copy of that if you'd like.
Ah, you guys are funny.
Because then you don't have to deal with losing it every time. Just have it in front of us.
Okay, so it's true.
That never hurts to
Okay, here we go.
Had a bartender?
be
But
prepared.
the 701,
Yeah.
but 701 like is expert, so.
Yeah.
They can say that they.
Ah.
I probably
Just to be an
did.
expert witness, you need a basically degree.
Yeah.
It's not,
Yeah.
just an experienced bartender.
So we need a scan drop.
They get some punchline, they get some
I will probably.
You can't
Yes,
tell me
I
all
do.
the things on the text and all the state, that's really hard.
Oh, my goodness.
Okay.
Their job's to know if somebody's intoxicated, cut them off.
Oh, and what's ER? Because here's the thing,
That one's here.
so I'm also using you guys too to make sure that these are right.
Yeah.
Okay.
Oh, nice.
So ER 803, the lab report of the expert unable to appear would be inadmissible as a business record. Is this true?
Yes, because it's not a business, it's an
No,
inadmissible.
because it's regular exception is lab.
Lab report of the expert.
But so it's inadmissible as a business.
Yeah. So
It would
this
not
is
be admissible, it's
That's
tricky.
false.
yeah. This is actually true.
What you're saying.
The lab report of the expert.
No. Okay. So hold on one second here. So this. So right now,
The lab
so
report of
right now, we actually have two of these things that are,
Oh, no, that is true.
so this is,
Hold
hold on a second.
Evidence of the plaintiff having abortion like that.
All right, so let's go back.
Likely be admissible.
I think we have two good answers here. We have B, this is good. Do we agree that B is good?
Mm-hmm.
Because we will look at 701. Do we think a lay person? He's not an expert, but the bartender 10 years, it was brought a lay opinion as to his
yes,
perception.
definitely.
That he
That's
was
true,
intoxicated upon leaving. I think so.
Yeah.
Right? You with me?
Yeah.
And then I think under this D right here, I think this is true. The lab report unable to appear would be inadmissible as a business record. Do you guys agree with that? Go back and look at E. What's 803 relate to? Hearsay, business records, right?
Hearsay. Yeah, because he would have to show for it to be.
Exceptions to hearsay.
Lab reports are an exception.
They are?
Yeah. I don't know why I remember that.
So do you guys understand why we
The
would need
lab
to do
report
this?
is an exception.
Do you guys know why? So here's the thing. I'm gonna fix this question. So we got two things that could actually be true here. Okay. So that's what I want you to understand. This one is good. And under this one, what do we say about the expert report? Why is this one not good?
Hearsay, right?
No, remember, we got hearsay, but here's the, exactly, the person will be on the stand. So 803, when we talk about business records, right? We're talking about some like finance, maybe like maybe like your banking records or something, right? But here we're talking about an expert report. Really? You're gonna let that come in under hearsay? I missed the opportunity to cross-examine on an expert report?
That's true. Okay, so I see what you're saying. Yeah, so it should be admissible.
So yeah. So we're gonna say the lab report unable to appear would be inadmissible.
As you said that, you lose your opportunity to cross-examine. Yeah.
Exactly. Okay.
So yeah.
All right. So we're gonna so on this one right here, this is what I'm gonna come back to because we actually have B and D that would both be true, and that's what the question was. Which of the following statements are true? So we have B and D that are true. Did I lose anyone? Is that okay?
What about A? Did you talk about A?
A is not true.
It's because it wasn't fine.
Ariel 6 and 9 deals with
Yeah,
crimes of
because assault,
dishonesty.
yeah, it's dishonesty. Yeah, there's nothing about assault being dishonest. All right.
Here's the thing.
Had an abortion with like.
This is why I'm saying that like the questions are really the softball things. This is kind of where we make sure we understand the foundational stuff, all right? Because we're not even at the application stuff, even though we have to do a little of that as we go through the questions. So civil procedure is just all about rules. So we're reading to make sure we understand the rules, okay? All right, okay, let's erase this. This is good, I'm glad we're doing this. All right,
So am I.
okay, let's do another one. All right, a photograph of the damaged car is an example of what type of evidence?
Oh yeah, yeah. We did this other.
So we got a photograph.
Yeah.
Demonstrative.
What do we call it?
You really want to say it's demonstrative, okay? So I'm gonna put an arrow
That's
here.
what I think it is too.
Is it gonna be testimonial?
No,
Right, okay.
not physical. No.
Not physical.
And for some reason, I don't remember why it's not.
Yeah, there's a reason why.
Documentary was done,
Yeah, that's not it. It is done. Yeah.
All right, good.
Documentary is only if it's written.
Are we okay with that one?
Yeah.
Okay. Now here's the other
Remember
thing.
they having this on the test already.
We've talked about it in the context of being demonstrative. I think you should think of it as being demonstrative. But I know in the past, if people put documentary or whatever, I give you like half a point. But I'm telling you now, you really should be on the demonstrative. You okay with that?
Half a point for that.
Okay. All right.
How many points is the final word?
Your final exam is worth.
Kind of like the quiz is 35 minutes.
No, hold on one second. Let me see here. 50 and exam is worth 125.
Wow.
How many questions?
Oh my.
Okay, so we're going through the questions now. All right, so let's do that. Okay.
Make or
All
break.
right, let's see here. All but which of the following state? Oh, this is confusing us. Hold on. I gotta remember to erase this stuff.
Yeah.
Okay. All but which of the following statements are true? So all true, but there's something that's not true.
But.
Is that okay?
All but which of the following statements
All right.
are true?
So the duty to preserve electronic evidence commences when dictated by a specific statute.
What?
Is that true?
Yes.
So first of all, you gotta understand what this means. The duty to preserve electronic evidence
Commences when dictated by specific
commences.
statute.
What does commence mean? Starts, begins.
Yeah.
Okay. Electronic evidence. What are we talking about?
Like anything
Email.
recorded,
Emails, documents, whatever, right?
Yeah.
When dictated by a specific statute. Could it begin then?
Mhm. Yes.
Okay.
It's
All
true.
right, let's keep going. The duty to preserve electronic evidence commences when the party first knew or should have known the evidence is potentially relevant to the pending or future litigation.
True.
Spoliation is the intentional failure to preserve electronic evidence.
True. Yeah. Well, no.
Oh.
I don't think spoliation is there.
I
Ooh.
don't think this.
Why do you think it's false?
Spoliation isn't.
All right, we're gonna come. Okay.
Really?
All right. Let's
I know
go
why.
on. Okay, let's keep going.
Yeah,
Okay.
spoliation is accidental.
Once a duty to preserve commences, the duty requires a party to prevent the destruction or corruption of that evidence. All right, so we're pretty sure these are true. True,
Yeah,
true, right?
Yeah. So.
Spoliation is the intentional failure to
That's
preserve electronic evidence.
No, spoliation is like accidental.
You're on the right track. You're on the
It's
right
just like
track.
when-
Well,
This is
spoliation
why.
is not necessarily intentional.
That's exactly why it's wrong, and that's why you're on the right track.
Yeah.
And that's why you got to be careful.
Yeah,
It's not. It doesn't have to be intentional.
Yeah.
And the reason why that's critical, and we emphasize that in your context, is because if there's something that happens on your watch, it's not going to matter that it wasn't intentional. It just matters that it wasn't done, it wasn't preserved. Okay? So this is the one, not true.
But then wouldn't it automatically make you wrong because all of the above are not correct?
No, that's just all.
No, all you're saying, all but which of the
That's
following statements are true?
true.
Are true.
No.
Okay, so read it on its face.
Read it on space.
A is true, B. So C is.
Technically, E is not true.
But it doesn't relate to.
It is. Yeah.
All of the above are correct.
E is not true. I know,
B is not true.
E is not true because then the
Yeah, you're right.
Yeah,
He is
so
not
we'll
true.
see.
So
But here's
just
the
C and E.
No, I get it, but
All
Oh,
right.
you're
But
trying,
here's the
you're
thing, though.
trying.
I understand what you're saying, guys, but you can't fight with me on basic construction of questions, okay? You know, okay, all right. So if you want to dig that battle out, then I want you to think about that in terms of taking other future tests, okay?
I got too many battles to fight.
You're gonna
I'm good.
have questions that are formulated like this, all right? You need to understand that,
But I like
okay?
to picture
Just,
everybody.
okay, raise your objection so that you can fight with it later about it.
Alright.
You get it back right?
Well, here's the thing,
Preserve your.
all right? But now you're on notice, and you've had your opportunity to be heard,
And
and now you begin a full explanation. All
Okay.
right. So when you get to
it's already
this
been-
final exam question, if you mark E, I'm gonna take double off. All right.
Don't worry, both of them are better explanation.
But I'll put a smiley face though.
Sorry, I keep
All right.
I'll mark you wrong, but I'll give you a smiley face.
Right. Okay. So let's erase this so you don't confuse.
Yes, thank you.
All right. So notice pleadings, authorized by the Federal Rules of Procedure and adopted by many state jurisdictions, requires the body of a pleading state in detail the facts in support of each element of the rule of law or claims.
True.
False.
No pleading on
False because it doesn't have to be detailed, does it?
Well, what's notice pleading?
Notice pleading is.
Don't guess, people. Here's the thing. Here's exactly why I emphasize to you that all your stuff is open book. In the field, I don't want you to guess. I want you to go and look to the rule. And that's exactly what you're going to do. You're going to go back and you're going to look to the rule. Civil procedure, criminal procedure, it's all about the rules. Now, some things you're going to just come to commit to memory because you're going to work with it so often, right? But in the absence of actually knowing it for certain, I'm still going to check. But in the absence of knowing for certain, you're going to go back and you're going to always check with the rule. Why else are you going to always check with the rule?
Make sure nothing's.
Because they change all the time.
Yes, they do.
You okay?
Yeah. I'm gonna apologize ahead of time to class tonight. I mean, we're goes on.
No, you're
Are
fine.
you getting really sick?
Yes.
Yeah.
It was lovely. I was tucking her hand and I'm like, I won't get sick. I'm done really good about not letting her cough on me. I go to give her a good night kiss and she coughs right in my mouth.
I've just come to the point now where I just kiss them, make them kiss each other, and let's all get sick at the same time because I'm tired of bouncing back and forth.
Dylan, my boy that's always sick all the time, is now he just completely doesn't want to stay there.
Yeah.
Have we ever, if we absolutely need to, something happens,
What now?
like if our, like something ever happens in, at the evening classes?
I don't mind at all. I mean, but make sure you ask each individual instructor and don't.
Okay, because I may end up having to bring that off.
Initial bleeding is abbreviated for GAC.
Oh, it's right there, it's a false. Yay!
153 is for them.
All right. And so why is it false? So why is it false?
It doesn't have to be in detail.
Yeah.
No, what
And
was that like?
it can be misleading though, because what do you think? I mean, because the idea of notice, you think, okay, if you give me notice, you're gonna be a whole bunch of stuff. Okay.
Adopted by many state jurisdictions, prepared a brief for-
Huh?
Why is it false?
So why is it false?
It's not in abbreviated form. Yeah, it's not in
Yeah.
detail.
As opposed to what's the type of pleading that's really, really
The
detailed?
complaint?
Remember, we're talking about how the pleading in the complaint can be done. We can either do notice pleading, right, or we can do, there's something else. Yes, fact pleading. And what's fact pleading?
Factual allegations.
Oh, that's
That's the detailed one.
That's what number 5 is supposed to be.
Very good. You guys are okay with that?
5.
So now if this said fact pleading,
That would be correct.
or whatever, you know.
So it's false because
So is everybody okay with that? Okay.
fact pleading
Yeah.
is the body of the complaint must state the ultimate facts in support of each element of the rule or law.
Okay.
So what,
Yeah.
between the fact and the notice one, when would it be better then to do?
It's gonna be dictated by your jurisdiction.
No.
You want it to be abbreviated, don't give them all the facts right away.
All right, are we okay with that?
Yeah.
All right.
I'm underestimating my notation.
So per
Okay,
rule,
not now.
Yes.
next question?
Yep.
All right. It's 9:30. Let's do a couple more questions, then we'll take a break. Is that okay?
Yeah.
All right. So per Rule 38B of the federal rules, a demand for jury trial should be in a conspicuous space and thus cannot be within the complaint. Are y'all guessing? Did you read the rule?
No.
Here's what I don't know. So final exam time, I don't want you to guess. I want, because it's all about your ability to read the rules, okay?
Rule 38B.
So Rule 38B, so you gotta go and you gotta read the rule. What's 38B say? Okay, I'll click on it.
All right, let's find out what Rule 38B is.
It was 38. Right to a
Right
jury
to
trial.
a jury
Man.
trial. Demanded party may specifically should be wishes to have tried by a jury. Otherwise, it's considered to have demand a jury trial on it. If the party has demanded a jury trial.
What do you have to do?
Which
Demand.
may be included in the.
Demand
No later
jury
than
trial,
14 days after
basically.
the last meeting, the
Right, a trial by jury as declared.
Can you go back to the question?
Yeah, it was a question.
Are you sure you're ready to go back to the question?
So-
Are you sure?
When written, which would be included.
Wait, a party makes a jury trial unless.
It doesn't say in there where it needs to be on the thing, right?
The party may specify the issues that it wishes to have tried by jury.
Do you have to go someplace else?
Yes.
Jury trial on
So it's
all.
not that
Just
rule.
to make sure.
Yes, so it's not
What?
that rule.
Yes.
What did you say?
Very good. So, no. You don't know the answer just yet.
No, we don't.
Because you gotta do something else.
Okay, then
You
it
gotta-
says
Something else.
You have, what else do you need to do to make sure you got it?
5B.
You gotta go to 5D.
Yeah.
Thank you.
5D.
Are you guys totally hating me right now?
No.
But you see the point, right?
Yeah, I see the point. You want us to know our rules.
But that's still confusing me,
Yeah.
actually. Your
You
question
want
is
us to,
based
you
on.
want us to know our rules.
38B.
Look it up.
No, but you want us to look it up and then know it.
That's right.
Filing.
I see what you're up to.
Yeah, she's making us.
Just make us learn the rules.
I want you to be familiar with the
Exactly,
rules, and
yeah.
sometimes you're gonna have to do a link and so forth.
Yeah, I see
Okay.
it. That's cool.
Okay, so what did we?
So let's look up 5D.
Alright, so look at your, so that I can't pull it all the way up so you can read it in whole. But what I want you to do, can you guys use use something to pull it up and read through the rule real quick?
This computer.
Oh, excuse me.
5D. Yeah.
Can you stop just trying, just stop trying.
I can get it all the way, there we go.
I freaking hate your computer.
This is a brand new one.
I don't care. I hate your
You get your
computer
computer?
so much.
Yeah.
Nice.
I like it. I can see a lot better on it.
Why is it not connected?
Let's wait. That must be it's a long one.
Is everybody getting too cold? Because I can put the temperature back
Yeah,
up.
can you go back to questions?
Now.
Yeah, you gotta like that.
Because I put it down a little bit.
Should be in a conspicuous space. So that's false because it's not 13B.
I remember this somehow though. Why do I remember this?
Can I have my jury demand be in my complaint?
Action service process.
Yes.
Rule 5.
Can I?
File.
Can I? So why do you say yes? Give me a rule.
Say yes.
The party feels that it was
Isn't it kind of answer the complaint if it's
I'm going according to your notes, and it just says demanding because it's illegal.
I know. I just wanted you to find the
And it
rule.
just says Rule 38, C38, CR38 that you gave us.
Mhm.
So you have a right.
So the
to
right of a
begin
jury
with
trial
your
is declared by the Seventh Amendment to the Constitution for the is preserved to the parties. On demand, any trial will issue right by a jury, demanded jury trial by certain the other parties with a written demand, which may be included in a pleading.
No, not.
Yeah.
Because now that.
Is your complaint a pleading?
Yes.
Yes, it is. Following the demand in accordance with Rule 5D, just in terms of what your service has to be like and so forth in serving. Okay?
I'm still confused by the way the question is
So
phrased.
you can,
So is your question true or false?
And it says it does not be so.
So it's going to be false.
Another rule to look up.
Because it can be.
can be.
Because it can't.
A
Cannot
demand
be.
for jury trial should be in a conspicuous space and must not be within the, no. Can be, yes. It's
Okay
false.
with that?
So the answer is false, right?
Yes.
Because it's saying it cannot be within the complaint,
Right.
which it must be in.
And so what you have to be able to do
Yeah.
is be able to read the rule and understand,
Yeah.
okay, a pleading, okay, a complaint is a form of a pleading.
Yes.
You with me?
Yep.
All right, everybody okay with this?
Yes.
Hey, good morning. All we're doing right now is we're looking at questions on the final exam, and we're using it as an opportunity to just sort of foreshadow what our the type of questions that will be there. But we're also using it as an opportunity to sort of take a pause and review. And what we talked about is how when we get to our next couple of weeks, we talk about motions practice. A lot of our basis for our motion practice is going to be based upon these sort of themes and concepts that are in the questions here. Okay? All right. Let's see. The cap, oh, sorry.
Oh, there's more. Okay. Yeah.
That's, I know it's kind of confusing. I don't remember the rates. Okay. All right. The caption of the complaint must include all but which of the following information. So, all right. So hold on a second. So we got to remember what the caption.
I think you should put the little dash at these.
Yeah,
Slant,
what's the
so we know that
dashes?
it continues to the next page, please.
We do listen to
Adjust your page breaks.
Push it down.
Point noted. Thank you.
That's good.
Your instructor is a work in progress herself. I am followable. Okay.
That comment on one of my papers.
In fact, you guys. Ah, no, you're right. You're right. No, we do make mistakes. We do make mistakes.
Come on.
You guys, in fact, I made a colossal mistake in court last week. I felt so bad. I mean, it was, when I say it was a mistake, it was terrible. This guy, we were in court on a motion for contempt with respect to his spousal maintenance. And bottom line, he just didn't pay it. He don't want to pay, he didn't pay it, okay? And so what I did is I filed a motion to have the court maybe suspend, because you can ask for a moratorium, like for a period of time when he doesn't have to pay, so he can get his stuff right, because he is going through some stuff. And so the court found him in contempt, which we knew anyway. That was going to happen, because he didn't have an excuse. He just didn't want to pay the woman. Although the woman should get a job, but whatever. That's neither here nor there. Yeah. So anyway, the court asked the lady then, like, okay, so what's the amount that you want, whatever, to add on to the spousal maintenance? And she doesn't know, she's clueless. And so I turn to my client, I say, well, what amount can you pay right now, just kind of dig you out the hole? And he says, well, I can make a payment of $600. So I then tell the court, I said, Your Honor, my client can make a payment towards the arrears of $600. He said, fine, I'll order $600 on top of the $750. I was like, Your Honor, no, that's not what I'm saying. Well, that's what I'm going to order. I said, Your Honor, you're going to put him in an impossible situation if you do that. Well, that's what I'm going to do. Isn't that terrible? Yeah. So I have to file a motion for reconsideration to get this judge to go back and...
Because he's saying he can't do it, and you're going to work.
Yeah. Exactly. So anyway.
I'm telling you, man, they love to nail you.
All right. So my point is...
Is it a female judge?
Yes, we make mistakes. Anyway, okay. Isn't it terrible? That sucks.
Female judges are going to have some kind of...
No, it was a male judge. I can't even go that way.
The male judges are worse, man.
He sucks. All right, okay, let's get back on focus. Okay. Number 7. So the caption of the complaint must include all but which of the following information. Do we need the court?
Yes.
Yep. Do we need the parties?
Yes.
Do we need the docket number and or file number?
Yes.
Do we need the attorney's name? No, they're not that important. Okay. The title of the action, yes. All right. Okay, it's gonna be in the footer. Okay. Alrighty. Under Rule 4, which of the following statements are true as it relates to the notice of lawsuit and request for waiver of service of summons? So we got to look at Rule 4. The process requires 2 documents: the notice of lawsuit and the request for waiver of service of summons. Is that true?
Under Rule 4.
Oh, you know what? Hold on one second. Let me see if I can do this.
Relates to...
Oh, it's not going to do it. Well, it's still going to be too little. Okay. So 2 documents. So, waiving service, the notice and the request. Do we have to have that?
Yes.
Notice and request. Okay. The defendant has 60 days. Do they have 60 days?
30
Yes.
30 days.
Oh,
No,
60 days.
16 is 40.
That's right. So it's 30 days. 30 days or so let's circle this, because it's 30 days if something, but 60 if what? So give legal time at 30 days after the request was made, or at least 60 days if the defendant outside of any jurisdiction, whatever,
That's what
right?
it says up there.
So what's our question?
You would
Outside.
already read it outside.
So 60 days return if we're outside, so is that right?
Yes.
So let's keep going. The notice of request must be sent to each defendant. Does that have to be sent to each defendant?
Yes.
Where do we see that at? Must be in writing to the individual defendant, blah, 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 blah.
That means one. I don't see how.
There's more than
Well,
one.
individual.
The individual.
Yeah, but individual defendants, each individual.
Okay. The defendant who fails to waive service of summons must bear the cost of service, including plaintiff's related attorney's fees, unless good cause is shown.
Yes.
Blah, blah, blah.
Yes.
Blah, 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 blah. Reserve serving for ways of failure to prove the service are required, blah, 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 blah. Where's our language about the, did I skip it?
You just said it, didn't you?
Where's that?
Failures to wait. Yeah, failure to wait. So you just keep moving around.
Oh, sorry.
Failure to waive.
Stop.
Oh, there we go. Where's our good language class? Oh, there we go.
There you go.
Sorry.
Without a good
All right. All of the above are true?
Yes.
Bam.
That was easy.
Okay. Service of summons and the copy of the complaint on the defendant is not sufficient for the court to gain personal jurisdiction over the defendant.
What?
Service of the copy, service of the summons and copy of the complaint on the defendant is not sufficient for the court to gain personal jurisdiction.
True. False. Whoa. Thanks. Hey?
It's true, and this might be a little bit tricky question for you, but this is true. And just make a special note here. This is one of the things that I talked about. How sometimes it might be in your if you read your text, it actually says the exact opposite. But this is one of the things where I told you that's actually not correct. Okay. Is everybody okay with that? All right.
So it's sufficient.
Is it summons and complaint?
It's not sufficient.
Well, I mean,
No. This is the time where we sort of flush all this stuff out. So ask your question.
It's not enough for the court to gain. Okay.
Yeah, so let's back it up, okay? So this said, because service of the summons and a copy of the complaint. So if I give these service, summons and complaint, right? Chris,
yes.
I'm going to give this to you.
Okay.
The summons and the complaint, right? And what this is saying is that this is not sufficient for the court to gain personal jurisdiction over you. Do you agree with that? Why do you agree with that?
Because I might not leave the state.
That's right. There are a host of reasons why you might not agree with this. And it all goes back to our initial discussion about jurisdiction, personal jurisdiction and subject matter jurisdiction, right? Let's say the lawsuit relates to a contract, all right? That contract is a contract that emanates from a business transaction in Hawaii, okay? The other party to that contract, they signed, and everything that relates to that contract is also in Hawaii. You with me? For some reason, they filed their lawsuit in Washington State, and you happen to be passing through Washington State and say, "Hey, Chris, how you doing?" By the way, you've been served.
Oh.
You with me?
Okay.
So now you have a copy of the summons and complaint. Is that enough for the Washington court that they have filed their lawsuit to gain personal jurisdiction over you?
No.
No. For all of those other reasons that we spoke about before, due process, minimum contacts, and so forth. Okay? All right. Third. All right, so this is the one that was kind of funky in your quiz, but now we fixed this, okay? All right. Well, let's see if we fix it. So Mr. Smith has filed a complaint against BB Furniture Store alleging negligence and breach of warranty. His complaint only named BB Furniture. So what does this look like? So this basically looks like Smith versus BB. Is that okay?
Yes.
All right. Mr. Cross, the owner of BB, believes the liability belongs to World Furniture. Okay? So we're going to put World Furniture down here. The actual manufacturer of the product. BB then filed under the same cause number an action against World Furniture, the maker of the furniture item, which is the subject of the suit. Which of the following is not true? Is not true. Okay? BB has 20 days to file his response. Is that true?
That's true.
Is that true?
Yes.
You seem hesitant. Is that your final answer? Do you want to call a lifeline? That's right. 20 days. So this is true. We okay with this? This is true, right?
Yeah, I remember that.
Okay. World Furniture's response to the original complaint is a cross-claim. So now let's make sure we understand. So World Furniture over here, their response to this right here, is that a cross-claim?
No.
Huh? Do we understand what, is that okay?
Yeah.
All right, so this is not true. Did I lose anyone?
Why isn't it true?
Because it's not world, it's B and B that's doing the cross claim.
Okay, so let's back up. So this is why it's very important that we parse out the party. So let me put plaintiff over here, defendant over here, right? And then this right here is the third party that BB wants to bring in, okay? And so the second part says, when they respond to this original complaint, the original complaint is the one that's filed over here by the plaintiff, okay? So when they respond, is that going to be called a cross claim? No. Are we okay with that? Did I lose anyone? Angela, you look like, is that okay? Is everybody okay? I'm not moving until I know everybody's all right.
So the crossway will be
We're not there yet. We're not there yet. But I just want you to understand right now that when they file their response against the original complaint, that is not going to be called a cross claim.
Okay. What is it going to be called?
That's where we're going. So B and B, the defending party. I'm trying to make sure we're all on the same page. Are you ladies okay? It's what the answer? It's what the answer?
Instead of cross claim, it's answer.
No. So here's what we're doing. We're going through each one of these prongs right now. Okay. So right now it says which of the following statements is not true. So we're just breaking this down tediously. So we said that A is true. Now we're looking at B. We said that's not true. And now we're looking at C and D.
She was wondering, like, what would World Furniture's response to the original complaint? Does that have a name?
Yeah. What is it going to be called? An answer.
That's what I just thought. Okay.
Oh, but it used to be is the answer. Oh, I didn't know. Okay, yeah. Is that okay? All right.
Okay, we got you.
Okay. We're caught up. All right. So B and B, the defending party, may, as third-party plaintiff, serve a summons and complaint on a non-party who is or may be liable to it for all or part of the claim against it. B&B's action against World Furniture is an example of a cross-claim.
Yes.
What do you think?
Sure.
What?
No. That's a little complicated right there.
So B&B, are they the defending party?
Yes. They're the plaintiff,
Okay. Can they serve a summons and complaint on a non-party
which is the fourth part, yes.
who is or may be liable to it
B&B.
on all or part of the claims against it? Is this an example of a cross-claim?
Yes.
If they do this?
Yes.
What do you think?
Well, they're
So you got to understand what a cross-claim is, what a counterclaim is, what third-party interpleader is. So these are all the rules that are behind this question.
A cross-claim is a claim by one party against a co-party in the same action.
That's right. So if we had, if B and B, these are both defendants over here, right? And WF, okay? So if B and B, if WF is already a part of this case, you with me? If they're already a part of this case, so the time the plaintiff filed, they filed against BB and WF. Then this is going to be, when they do this back and forth, that's going to be called what? Cross-claim. Are we okay with that?
Yeah.
But because they're co-parties, right? But right now, is WF a co-party? Is it co-defendant? Not yet. They're going to be. That's what he wants to do. So what is this process called whereby B and B says, oh no, if I'm going down, you going down, jump on this ship too. What's that called? That's that third party. The impleader stuff. Are we okay with that?
Third-party practice.
Okay. So B and B's action against World Furniture is an example of what? After this person is brought in.
Yeah.
Does that make sense?
Yeah. Okay, so they're
So
not,
right now,
they're not brought in yet.
But do we have,
I don't understand why.
As a third party.
Third-party claim.
The
WF.
way it's phrased makes it
Because
sound
we
like
have
B&B is the
Three
third
parties
party
in
claim.
there?
because now we have three parties, right?
Okay.
Okay. All right, so let's come back to this one.
Okay. Yeah.
B and B must assert any counterclaims that arise out of the same circumstances in the answer. Is that true?
Yeah.
Is this true?
So,
What does our answer have to have in it? When you did your answer, did you have to have your counterclaims?
yeah.
All right. So we got to go back up to this one. World Furniture's response. to the original complaint? Is a cross-claim? Not true.
So B is,
What's C? What's C?
it's true then.
Do we get Y?
Yeah.
Okay. And we are okay that so when we go back to our original question, which is the following statement says not correct?
It's B.
B. Is everybody all right with that? If you go back and look at the rule for third party, do that right now. Go back, pull up the rule for third party, and read the language. I'm sorry, I'm still.
Yeah, breaks down process. Breaks down
Break.
Yeah, I saw.
Oh yeah, let's take a break. Sorry. You guys have to remind
This
me.
process is like a cross claim except for that it's a previously unnamed party. Authority of any Which books do it?
I know. I'm from
You
my
can
dad.
here.
What's it going to?
Oh, we're taking a break.
Take a break.
Okay.
Wait, we gotta stand up.
Yes, we don't have class tonight, and then we don't have.
You don't have class tonight? What?
No, we're not on your class tonight.
You do tonight?
Like, why don't we have class
I'm done
tonight?
with the
God, it's so
report because
hot.
I'm not done with the questionings.
How was I able to copy this just a few moments ago?
Well, because the last part is the questioning, so it's like, I'm gonna skip it, and I'll do it the next following days. Because I need to think about it. Like, there's 3 questions in every scenario that you have to make. So it's like, oh my god, I'm gonna personally.
Oh. Now what happened? Did you guys see that?
Yeah, like the open-ended question, the closed-ended, and then what topics are you really gonna ask? Like, how are you gonna dig into it? Yeah. What do you really wanna know? Like, where were you at the night class? No, well, it's more than that. Well, the homework is like, there's 5 scenarios, 3 questions.
Okay.
The other one. Okay. So the final one? I don't know, that I'm not. It was just like the homework.
The homework,
There's-
I get that.
Yeah.
It's
The last
not-
one.
The only reason I find it is because it goes on the right side, and then it tells it.
Oh, yeah. Yes. Yeah, it's not on my to-do list
Oh, and we
too.
have until when?
Yeah, how long do we have for a break?
Oh, you guys, let's do. How long do you need?
I'm gonna run over there, get breakfast, and I'm back.
All right.
Yes. Not like that. Oh. This is like every other day, go to school this week, because we'll have class tomorrow.
Kinda.
Legally.
So let's make it. Somebody's.
Oh, Rowan. Okay, it's time to start saying some really nasty things now.
Hypothetically, if someone was asked to write a character letter for a child custody thing, what would one put in it?
Who is the character letter for?
The mother.
The mother. And do you know what the facts and circumstances are related to the case? You don't have to tell me, but do you?
So, I mean, everything just, hypothetically, let's say everything just got started, just filed, and the attorney for the mother is going to go ahead and start gathering letters.
So we take German instructor and not copy it in citizenship. Okay. And it's affiliation on the case. Because I don't know if you know the role of the party and not have a lot of affiliation. And so, I would want to see the representation. You want me to explain what you see knowledge, how you know this person. Or you use someone not just who I can engage with you, your practice, or I want to look out your own children. Then we spoke to, described to her, I would want you to give me like that. Where you see her young children, how about her, does she know what this position is, her family, her philosophy, where your children respond to her, things like that. That's what and I want you to be very, I want to be very objective. And to the extent that you don't feel concerned about being very objective, and you were to raise that, well, because to the extent that you did go there, I would be very objective. And I would want that to, I would want to feel the objective nature in the language that you use. So let me give you an example. While I'm somewhat less familiar with the plot, with some of the plot of the child, from my limited interactions, what I observed is da. You see how that you qualified it? So, you know, like that is objective. You're saying, look, my interaction with this person is a little bit less, and I'm owning that. However, from those little that just really needs to process being a little bit more sort of like, someone said it, they're like, why? How do you know that? You know,
Stupid children.
man, children,
I know.
Have you seen the movie Live Die Repeat?
Have you seen Melissa?
Yes, bring it like
A red box and run each night.
where I go, when we're gonna hang out, where
I don't live there. My one place my class. I bet they live there. Like, it's great. I really want to see that Interstellar though. I keep hearing people talk about it. I'm not going to do it now, but
I'm gonna say Live Die Repeat, so it sounds like more fun.
yeah. Well, I'm ready for it. But tomorrow,
but it's Tuesday, like you want to make
and
sure
the
that
theater
you're
rather than by 5, you work there.
when you write a letter,
Every Tuesday, it's $5 to get to
that's
the
close to that person.
I know to go to the kids
I
to see
see
that.
yeah.
big
Or some
hero
additional context.
whatever. I was thinking about it. That's the movie
that's
I'm
going to be
going to
objective too. You know what I
Okay.
mean? Think about it this way. They all know
It's well, but
you have a
I was
vested interest.
I was really happy my dad was kind of sticking up.
So then today you
Yeah,
can
thanks
so
for the recording,
right?
right?
So here's what information I can offer. But you're able to couch it.
You left, she's like, oh, somebody's talking about we'll try to say dirty things.
Because a lot of those things that I would read,
Well, we did.
that I would read as a GL.
Other than you probably have that.
It's so obvious to this person. You know, saying, oh, this could go for it. And I dismissed it, or I put it on the bottom of the pile. I'm willing to build something that can be a nice narrative, but it's clear, like, okay, this person can only think about me too.
That is a dirty
So, for
thing.
example, like a good friend, my singular concern, or one of the things that has concerned me, even in my observation of this person as a mother, you know, I do think she tends to kind of work a little bit hard. I sometimes wonder if it's sort of, stress. You see, I'm being objective. You see what I'm saying? But you gotta get the self interest. I don't know how to find it. Yeah, like I really don't have emotional connection. No, because how long have you known them for 2 years? And in what capacity? Do you go over, okay, do you go over lots of family gatherings? All right, your kids are engaged in sports together? They go to school together?
It does.
This is not even good. Think about it this way. When you write a declaration, the bottom line is on the back. As a board, I want to know who the hell are you, and why should I listen to what you have to say about this person that I know you have a vested interest in? And that's just part of your narrative. But did the attorney just ask you to write something?
Yeah, she said, the attorney asked her gather
Not like that, but I mean, like, if I ask you to write a letter, I'm gonna call you, we're gonna talk about your letters Wednesday, you're gonna draft that letter, I'm gonna read it to you, and ask you to verify your same thing in there and then. I'd love to give you some problem for
For what?
Get a free red box rental tonight. Looks like it's a promo code anybody can use, but it's only for tonight. Does anybody else like getting red box movies?
I will call you and I can put that later.
Oh, they do that. It's just NOV10. Never tell sister. The free red box tonight. Yeah, why not?
Red box?
Even if I don't watch it, at least I don't have to pay for it. The trick is not forgetting to turn it back in tomorrow.
How old is it?
No, more like 40.
Like he wants his farm, he wants his bacon.
Oh my.
How long
Love
have
the
you
job. Oh, yeah, I was gonna say,
It's
that's
not
what's
necessarily,
going
I think just do like that.
Well, they start early.
Well, here's the thing though, like you said there, I take my one dish back to ship because we just looked at the video of this 16 years and we got 4 kids, right? I don't know, 16 years is a long time for marriage. Every people get, you know, people get burned out. I just happened to turn this like there's like this man, you know, kind of like.
You showed me the
Yes.
you showed me earlier.
Of what?
Fine.
What's
the picture of?
Is this interest?
Yes.
Okay, fine.
And I was in love with him before I saw that picture, so
Who is this?
my eyes are watering.
It's a good picture.
Idris Elba.
Oh.
It's a
He's
good
in love.
picture.
So now I know what you do. That's why you don't know the answer. The interview questions because you this is where your mind is
I
at.
just got that picture.
You don't know
British
that's
actor,
what
right?
You put that on the back of all
I know.
the
Yeah, I'd be like, I'm in love.
She's like, oh, especially that part where it's written.
And it's not just the accent, right?
Word 42 plays ago. That's
Uh-oh. Yeah, it's beautiful.
What are you doing? You trying to get her attention?
Oh,
yes,
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 yes.
yes. Sorry,
Oh,
sorry,
oh.
yes,
Yeah.
yes. And smell funky? Oh, you had something last night? And walk around?
Oh, great. I must not. Okay.
I need Chris at the bottom. A molded spoon in. Gotta take some kind of spoon in another one. Lord.
Very stressful.
You okay?
Huh?
You okay?
Oh, I'm good.
Thanks. Big people that are on it.
Well, you had it before.
So she slammed her hand in the door. Or you guys
Yeah, I filed a restraining order against her.
Yeah.
Yeah. Only because she was filing one against me. I never would have done anything. I don't want her to go to jail. You know?
But you need something. You need to start documenting.
Yeah.
Oh yeah, it's in the declaration. It's filed with the courts.
And so now, especially when you go to argue with Nancy, when she's probably gonna keep going, here's your party here.
Yeah, no, that's, so there's a declaration filed and there's a restraining order. I got one against her. She got one against me on Monday. Monday we're gonna be in court
Okay, so-
to see if we can get these taken.
So we
further,
could get
I
started,
think we
but
should drop
Tiffany is not back yet.
them in the butt.
We'll wait for Tiffany.
We'll wait
So
for
I can't
Tiffany.
even go to date.
Isn't there
Drop the kids
princess
off.
called
It's not gonna
Tiffany?
work.
I'm not
So
sure.
it took me like almost
I have
45
boys,
minutes just to get them
I
into the daycare.
Oh, so you guys would have to do the Princess Diary and Selena Gomez and,
No,
you know,
not yet.
you were spared.
Not yet.
Yes, but I can attach it. It's my favorite.
Well, see, I got that too.
Because then they
Yeah,
come
yeah.
to
That's why she tried to get it, because she knew if she got it, she was trying to get one against the children. She knew if she got it, she wanted us to take it. My
Hey,
son.
mommy, wake
Oh,
up.
they planned this from day
Oh,
one,
yeah.
actually, they were already trying to get it before this even happened. They had it filed like a week or 2 weeks before this even happened. They were trying to get it.
So,
That's just the easy way to win.
Yeah, I know.
And people don't realize they let that go. And
He's so
sounds
smart.
like this.
Oh,
Hey, sweetie,
I love this.
take,
that
go
was
to
the beginning
sleep
of the
this
end for a friend,
weekend,
no
no
friends of ours
school.
that split up and she
Do I have
pulled
to go
down. She was
back
like,
to
wait,
school?
whatever, she feels like.
And she's just gonna go down.
And then it turned, then she turned it into a custody.
They're just gonna
That's
say,
why I
mommy,
couldn't
wake
play
up.
And he's like giving up now. He's like, I'm done fighting for this.
I'm ready to give up too, and I fight him even started.
Yeah.
It's too much, it's too stressful.
I've seen those.
I love my children.
Hope it turns out.
You guys,
Don't give up.
Oh, I'm
there's
not
no
giving
school
up.
tomorrow, right?
I love my
No.
children.
Those kids need to know that you.
You get a day off.
They do.
No court tomorrow.
I don't know, school
No
on
court
Tuesdays
tomorrow.
Nothing is going on.
Yes.
No court, no band.
What are you guys gonna do?
I'm gonna.
Laundry.
Schoolwork?
I'm gonna
We're gonna
lay
study,
around and
right?
sleep all day.
I might go to the mall.
Because I help clean my house.
Did you say help you clean your
Yeah.
house?
Yeah.
And I'm gonna help her whenever she needs any mechanical work
In
done.
a room full of women, he goes, have help me, yeah.
No,
We should just close the
We
door.
have an agreement because I have a Honda and he knows how to do all that stuff.
Oh,
And
okay.
my ex used to do all my car work, so I'm
So
like,
there's some equipment
I will
pro
come
here.
help your But you're gonna come anytime I have a car issue, you gotta be at my beck and call. This is how this works.
So we have a good contract here.
Yeah.
Anybody taking contracts just yet?
I am.
What kind of contract are we gonna call this?
And now I know where he lives, so if he doesn't show
What
up, I'm
kind
going
of contract are we gonna call this? Is this a unilateral contract or a bilateral contract? So bilateral contract.
There to use this, right?
Thank you.
Now, even though that class is really hard.
Yeah,
I'm
no.
not taking it.
He's doing all my car.
Contracts is
Because I'm
fun.
taking e-discovery next quarter.
That's an intense
And
class.
should that be teach online?
Yeah, it's online.
All right, we ready?
No.
It's intense.
So
Get
should
ready.
it be teach
You're not supposed to be
Yeah,
doing
the
it.
class. Approach it like a 5
We're
waiting for you.
It's
Finish.
intense.
We gotta go.
We got to wait.
Yes, we were.
Yeah.
Yes,
So
we
we're
were.
waiting for the bathroom. I see her mom come out of the bathroom.
It's just wrong.
You guys go.
You got M&Ms. You know, you come with your carbs. Next time I'm putting my syllabus, no food in class.
I got my breakfast.
Until I'm done with the actions.
Look
No
at
food in
you.
class.
You have made noticeable difference since
Oh, yeah.
the beginning.
Thank you.
Like you walked up the stairs and we all went, damn.
I'm getting braces today. It's
Oh,
all
really?
like
Oh, my
Are you
God.
getting
Yeah.
braces today?
Really? What kind of braces are you getting? Are you gonna get
The
the
metal ones or you
metal
get
or the
I think
invisible?
metal. The invisible
That's
ones
okay.
work for me.
Oh wow. Okay.
That's weird how we do like.
Interesting. So how long an appointment is that gonna be?
2.5 hours today.
Oh,
Oh,
darn.
geez, 14 months, you said?
Do you need to go today?
Somebody was just showing your house. I love you. I'm so sorry. Like, no. I run away now.
Get some of
I
that
think you should
Anasol, Zorine, or whatever that stuff is.
feel like
That works too.
Ew.
Take a couple apps.
I worked my
Yeah.
19 months to the dentist last time, and they were like, well, we're gonna wait 2 more years and we might put her on braces. Because her mouth right now is crowded.
Who's?
Her daughter.
Are you
She's a toddler. There, don't let, no.
Get a new orthodontist.
Because they told me it's too crowded. She had a lot of teeth, and it grows her teeth 2
But
times.
they're baby
Oh,
teeth,
no.
they're baby teeth, that's okay.
That's not
Those
okay.
are baby teeth.
Like my son's 10 and we were just told last week.
How
that
old
he
is your
probably-
child?
19 months.
Yeah.
19 months?
Braces until they have adult
Almost
teeth.
2.
And they want to do braces?
No, not now, maybe 2 to 4 years from now.
Oh, okay.
Oh.
So
mm.
they're still
Yeah,
baby
so
You
teeth.
don't do it until their
No,
adult
no.
teeth are in. No,
You're
no,
supposed
no,
to
no.
start taking the orthodontist at 6 or 7 if they have.
As soon as
Yeah,
the
yeah, mine's going in because he's gonna have to have teeth
10
pulled,
years.
because some of his baby teeth. 'cause they
I
don't
mean, you
come
can
out.
take him sooner than that. I'm just always curious about like doing stuff that you know is gonna fall on you.
My son has.
Yeah, we start taking as soon as they start like they have like little teeth.
Oh, yeah.
We take them in.
Yeah.
It's just kind of fun to get them used to it.
My, our facial cranial clinic.
Yeah, my.
No. Just a regular little dentist.
Our
Yeah.
facial
Oh, well,
cranial
that, yeah.
clinic.
First time they
said not
had
to
one
go
tooth,
outside.
they went to the
Yeah,
dentist.
yeah. It's just kind of fun.
It's just good for them. to
I have
get
a
to it.
great dentist too, if you don't already have one, that's good.
I have a really good one too.
She is amazing with the kids.
I need to switch. Well, my kid's dentist is good.
It's a
But I hate my dentist.
I switched to her husband. They work at the same office. Her husband does the adults, she does the kids.
Alright, you'll have to take me while I'm a big ass baby doing it. So.
All right, so let's go ahead and let's do some more questions, okay?
That sounds good to me.
All right. So.
We're on 11.
We're on 11 now.
All
right,
Did
so-
you figure out what 10 was?
Oh yeah, we were looking at
okay.
at number 10.
We can do
We
that.
did 11.
Did we do number 10?
Are we gonna?
Oh, the only thing I did is I pulled up the rule for you because sometimes I'm so obvious, like I just totally take and copy the language of the rule. So if you went back into the rule for third-party practice, you see the language. A defending party may, as a third-party plaintiff, serve a summons and complaint on another party who is or may be verbatim. Okay. Yes,
Question,
sir.
are we gonna be able to go over this on Wednesday also? What we have, or can we go over more of this on Wednesday or? we have time?
My goal is to sort of take us through most of, get us through just a sampling of the questions.
Okay.
But yes, we will we'll come back to this because you don't leave the concepts behind.
There was some, because you gave out a handout earlier, but some folks came in afterwards.
Oh
and
yeah,
everybody
yeah.
did.
Thank
No.
you so
I don't
much.
think Ian
Oh
got it.
my
No, I
gosh,
didn't
thank
get
you.
one.
All right, so those people who came in late, I gave out this nifty little handout. You can pass that back to him. All right, did we get everyone?
Did you get one?
I didn't think you. Sorry.
Are you done with your breakfast sandwich, ma'am?
I know. Lovely card.
And then she gonna brag about it. She's
my God.
so wrong. All right, I'm just kidding. All right, I'm just kidding. All right.
Carbs are so good.
You guys are gonna get attacked.
Do you like smashed potatoes?
Still have like a couple.
I have a
of
great
great
different thing for you
by
that's
the
better
way.
mashed
Oh.
potatoes.
Yeah, I know.
Oh, you better
Don't
watch
do
it.
it. Don't want to do that.
It's gonna be making.
What is it with mashed potatoes now?
Celery root. Celery root.
Somebody's your Canvas submissions are gonna just totally disappear. Oh my God, really?
Don't worry, I make copies. One for you and one.
Oh my God. All right. Okay, so let's under federal rule 56B, unless a different time is set by local rule or the court orders otherwise, a party may move for summary judgment at any time until 30 days after the close of all discovery. So then we click on the rule. A party may move for summary judgment, blah, 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 unless a different time is set by a local rule. Party may file a motion to adjourn at any time until 30 days after the close of all discovery. So it's just a matter of you just being able to read and understand the function and the rule. All right. Under the Federal Rules of Civil Procedure, there are mandatory initial disclosures requiring a party to give to the opponent a broad spectrum of information relevant to the case. A party must make the initial disclosures at or within 20 days of the party's Rule 26F conference, unless a different time is set by stipulation or a court order, or unless a party objects during the conference that initial disclosures are not appropriate in this action and states the objection in the proposed discovery plan. True or false? So, first of all, we got to understand, okay, what rule are we under? We're in the rule that's talking about, well, we're a rule that's talking about what? Civil procedure, but what under? Mandatory disclosures, right? So you got to find them within. So some of them, what I do is I'll give you the link to the rule, say here, go look at the rule, right? Others of them, I'll give you the language, and then you have to practice going through the rule to get to that applicable principle. So in this instance, based upon the question, what would you sort of do a search for? Probably mandatory disclosure, right? So let's have you do that now.
See, so silly. Are you still hungry? Hey, stop it.
Okay. Mandatory disclosures.
Can I ask you this moment of pause?
Yes, ma'am.
What are we going over tonight?
It's
What
on
are we
page
supposed to bring with us? What are we going over to tonight's class?
What are we going to go over
I feel
tonight?
like I'm missing, like there was something supposed to bring with us, but I don't think there was. Was there?
You know what? I don't know. I'm not in 152 mode right now.
Yeah, okay. I don't know why my head, my feet go back there. Other than redoing my class break, I need to return.
Rule 16.
Which is just to give disclosure.
What? Okay, thank you.
Oh, no.
Rule 20.
We're reading again.
What is it?
That was the wrong page. Okay. To be to disclose.
Within 14 days after the issue.
Says it's true or false.
I saw mandatory once.
There's like to be disclosed, but it's not like a party. That one. What's the question?
So look into the rule for disclosure. You look at the federal rules. Look at Rule 26. Get some hints there. A party must make the initial disclosures at or within 20 days.
This says at least 21 days of notices.
Yeah.
So it's just disclosed. In the case of
Because it gives you
26
Ah.
Yeah, okay. Within 14 days after the stipulated in charge by the court.
Would you just read? And it's what was it?
See,
At least 21 days
Yeah,
before
it's 21
scheduled
days.
conference is to be held.
26F is within 14 days of the attorney's plan.
Yeah, that's what I
Planning
was
meeting and unless otherwise stipulated and directed by the court to initiate the disclosure. The meeting. So, of the information that occurs.
Yeah.
All right. So you're looking under 26F, duty to disclose.
C?
You look under C. A party must make the initial disclosures at or within 14 days after the party's 26F conference unless a different time is set by stipulation or court order. So what's the time frame?
14 days.
14 days. What's the question say?
20.
20 days. True or false?
False.
False. Okay, so. All right. Under Rule 11. You did just say filling with the rules. That's all civil procedure is. Rules, rules.
Okay.
All right, under Rule 11, by presenting to the court a pleading, written motion, or other paper, whether by signing, filing, submitted, or later advocating it, an attorney or unrepresented party certifies that to the best of the person's knowledge, information, and belief formed after an inquiry reasonable under the circumstances, blah, 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 blah. All right, it is not being presented for any improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. Is that what you're certifying? What do you think?
Yes. That's verbatim. So.
Representation.
Rule 11. It is not being presented for any purpose. Is that there?
Yes.
That's true. Okay. Up. The claims, defenses, and other legal contentions are warranted by existing law or by a non-frivolous argument extending, modifying, or reversing existing law. Blah, 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 blah.
True.
Oh, where's that? Claims, defenses, other legal contentions are warranted by existing law. Do you feel with me? So it's just a practice of reading the thing. If we're going to keep going, we see that all these are true. So, all of the above. And then also fact, but read the whole question though. All the factual contentions are warranted on the evidence and so forth. Okay? Did I lose anyone with that? We kind of went through that one kind of fast. Is that okay? Number 14, the number of interrogatories. What's an interrogatory? Questions. Number of questions, basis for the responses. We talked about them being in hard copy form, but also being provided electronically nowadays as well. Number of interrogatories allowed by state court varies. However, under the federal rules, leave to serve more than 25 interrogatories on any other party must be granted by the courts. True or false? Find the rule.
This is familiar.
Find the rule. So, is your final exam looking difficult or is it looking doable?
Doable, time consuming though, so we get them home. But it's all gonna be in class, you said.
Are you like, I'll
Do
save
we
my
need to
comments for
purchase
after I do it?
We need to
Is it
purchase
rule
scantron then, right?
33?
Yes.
Yeah,
Is it rule 33?
Yes. Unless otherwise stipulated or by the
How many is it,
court.
25? Yeah. Are you
No
sure?
more than 25.
No, it's 35.
No, it says 25.
No, it's supposed to be 35.
No more than 25.
35, looking at the wrong rule.
Is it in my book or on
Gotcha. Okay, so 25.
What?
Alright, I'm sorry.
Yeah, I have
All right.
so
So
many as well in general.
Yeah, 25.
Oh my god, I was like, are you kidding me?
No more than 25. So
Alright.
true.
So no more than 25. All right?
Yes.
Okay, 15. A person who is subject to service of process. What service of process? What service of process? Yeah, well, it means. Fancy word for being served. All right. And whose joinder will not deprive the court of subject matter jurisdiction must be joined as a party if, in that person's absence, the court cannot afford complete relief among existing parties, or that person claims an interest relating to the subject of the action. So what are we talking about? What are we talking about here?
Joinder of parties.
Joined, that's right. Joinder of parties, right? So we'll look at the rule for joinder of parties.
So is it federal civil procedure 19A?
Rule 20? No. 19?
Permits the joinder or defendant with claims against the petitioner.
19 or 20?
So some of them I'll give you the rule, others you have to find the rule.
Okay.
First,
I totally stole your role.
Oh, Victoria,
Oh, it's
I thought you were
19.
going to call interest.
Oh. What you call that then?
It's 19.
Right.
So you tell me it's 19, what's 19 say?
I'll write it.
Requires joinder parties.
And where does it require joining the parties? Is it 19?
When a person is
Did you
subject.
stab yourself in the eye or something?
I know, okay.
Party company else.
Or the person
Cut 'em.
claims
I can.
interest.
Requires joinder of person.
Very good.
Just kind of help us right now, and I shouldn't laugh.
I'm
not
good.
good. Hold on. Jeez, why should I give you any time for
I can see this, I can see the first part. Yeah,
Not
I
my
can
fault.
see the first part, but not the second part of the wrong.
Not my fault.
Oh, she's the one who's not doing it.
Exactly.
Oh. Includes until one, B1 and B2, so yeah. It's A and B. Yes.
No thanks.
Why did you just call me tonight? It's not like you don't know my phone number.
Where you at?
19, 1, A, B.
Persons required to be joined if feasible, required party person who is subject to some of the process and whose joinder will not deprive the court of subject matter jurisdiction must be joined as a party if, in that person's absence, the court cannot accord complete relief. Was that the language of our initial part?
Yes.
Yes. And then we also had, or if that person claims an interest related to the subject of the action and is so situated, blah, 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 blah. Let's go back. Person claims interest related to subject matter, so may, as a practical matter, impair and impede the person's ability to protect the interest, or leave an existing party subject to substantial risk.
Yes.
Substantial risk, blah, blah, blah. So what's your answer?
C.
C, A, and B. So my take is that while the questions are involved, they are doable because all it requires that you read the rule. Okay, and if the rule is not given, then you kind of have an idea, okay, of what's my search term. What would I look for? Okay, this rule relates, or this question rather, relates to joinder. So civil procedure, joinder. Do my quick search, find the language.
Okay. So we can search through when we're doing the test. While we're doing the test.
You can search what?
Like the rules.
Oh God, yes.
Okay.
Yeah. So when I say open book, I really mean anything is fair game. So
Okay.
you just want to make sure you're using good information. That's all, okay? So your search should take you to the rules. So Chris, what I would not do is like say I were to do a search, whatever, trying to get this question right, and maybe it led me to like Wikipedia. I would say pick another source. Go to the rule itself. You with me?
Sure.
People, I'm telling you, people are not going to hide the ball from you in the field. They're going to give you the core rules. They're going to give you the websites to go to. They want you to come back with solid, correct information. So that's why it's always open book like this. Okay? All right. Under the Washington State Civil Rules, which of the following statements is incorrect? So one statement is incorrect, could be more, we'll see, but hopefully just one. Statement is incorrect as to when a party may amend pleadings and the requirements for such. So pause right here. So I didn't give you the rule, right? I didn't say under such and such, but I gave you what the rule relates to. So we're talking about what? Amending pleadings. So if we didn't know, again, so think about this in the field. Oh, I need to amend this pleading. Can you quickly look up the rule for me in terms of what we have time to do this? So what are you going to do? Washington State Court Rules, amendment of pleadings. You do your search, you come up with the answer. You do your search, you look at the language here, see what's true and correct here. Okay, same approach.
Go for P. When do I date?
One to the matter of course, at any time before response to pleading is served.
21 days.
Mondays.
If the pleading is one to which no response to pleading is permitted and the action has not been placed upon the trial counsel, party may so amend at any time within 20 days after it is served.
No, 21 days.
21 days. A party may amend the pleadings. A party may amend the party's pleadings by leaving the court after the original pleading has been filed. Well, duh. I mean, like that's the only way I can amend. I have to have an original document from here right first, right? Is that okay? The party needs to amend a pleading to copy the proposed amended pleading, denominated proposed and unsigned shall be attached to the motion. Is that right?
Right.
Is it right?
No.
No? Look at the rule. Look at the rule.
Did I
What's
say
the rule
something?
say?
I don't know, I feel like I need to yell at you. It just, as soon as you
I've had enough women yelling at me.
This is why you're here, so that I can take all of my.
You two sound like a couple.
I know.
Ew, thank you, sorry.
Oh, but that would be so cute. They can say they've been in Miss Jarman's class.
How are you guys meet? Oh, it's German's class.
I know,
When do you argue?
we're
Matchmaking is Civ Pro.
Yeah.
All right, let me stop.
The weirdest
You guys
one
are
I've
hands up.
ever heard.
All right, let's be appropriate.
I'm sorry.
We'll delete that video.
Party may amend. Only if parties written consent or the court's review with justice or requires.
All right. So, what's the time frame? So, what's incorrect?
B.
B. Is it how many is supposed to be? 21 days. Why? Do you see why the rules become so important? Because we got different days and time frames, whatever. We have no consistency whatsoever. We just can't pick 14 days or 20 days. Now it has to be 21 days. So the rules become so critical and key to go back to choose to rely upon, okay? All right. Let's see here. Let's tackle.
21 days. Oh man.
So I think you get an idea of those type of questions. Let's take a look. Let's do our last 20 minutes and let's take a look at one of the essay questions, okay?
Boy, okay.
All right.
One of the essay questions?
One.
I know.
All right. So what I want you to think about is doing a quick analysis in and out, okay? So you're gonna have some very specific things you're gonna do. Identify the issue, the legal principle or the rule, and the facts that support that.
Ooh, 25 points for each question.
And we're going to go through and talk about how you do this. So for this one, there are 5 issues. Okay, so that's our target. On April, you ready?
Yep.
On April 13, 2011. Oops, hold on.
Miss Andrea, can we go back?
Yeah.
The last
Yeah,
one.
because I found 20 days on here.
Yeah, it does say 20 days.
I found 15
Number
days.
16. 15.
Yes.
Where are we at?
That one.
16.
I thought I had 21 days up there.
You got 20
You had
days.
20.
Did I have it right?
That's
Yeah,
what
right.
I was confused on how
Yeah.
I was on 21 days.
I thought I had 21 days, and that's why you marked it wrong.
It's 16.
She's recording this.
Hold on a second.
It's number 16.
Thank you.
See, B says 20 days.
They didn't touch our own.
So I just want to make sure I have the right answer.
Yeah. So you meant to have 21 days on there?
It's 20
Okay,
days.
hold on a second. So as a matter of course, whatever. If the party moves to amend the, so go back. As a matter of course, before responsibility, we got that. Pleadings with responsibility remitted. Actions like placed upon the trial panel. Party must stay amended within 20
days.
Within 20 days after they're served. Okay, party may amend the party's pleading by leaving the court after the original pleading has been filed. If the party moves to amend the pleading, copy the proposed amended pleading, denominated purpose, whatever, should be attached to the, that was our last one?
Yeah.
True.
It's all, so we should have an E. Wait, what was my
Yeah.
question? Hold on a second. It's incorrect. What did I do?
Yeah, you forgot E.
Oh, okay.
21.
Yeah.
Either that or all of them.
No,
Okay.
no.
Well, when I was looking the rule, I was looking at Law Canal, it says 21 days, and now she's looking to
I'm
one.
looking
No,
at
no, no, no.
Washington State.
Hold on.
And she's-
So here's the thing, and this is we're gonna do exactly what ideally you're supposed to do here, okay? So we're gonna go back. You're gonna go to court rules. All right. We're gonna look at the court's civil procedure rules, and then we're gonna go and find amendments. All right. So pleadings allowed, and then we're looking at amended and supplemented. So we should be right under 15. And what I should have done, party may amend the proceedings once a matter of course. That's the first part of it, right?
Yes.
That's
Yeah.
true. Okay. One in which no responsibility, but that's right. 20 days. That's
Correct.
right. And then what was the last part? Denominated
Denominated
pleading,
right there. Yep.
proposed, and
That's it.
unsigned. So all of it's right. So we're just missing the E.
Yeah.
An E and a revise the question itself.
Why do we have to revise the
Because
question?
it says all but which of the following are.
Oh, I see. Okay.
Yeah. 'Cause it's only-
Got it. So I have to put E.
That's kind of
Okay.
cool that we're helping
Yeah, you guys are helping me write the
you.
exam.
Yeah, exactly.
Okay.
You gotta love that.
Okay, cool.
Showing up to classes and everything.
All right.
Sorry. No, it's all right. I'm glad you
No, good. Okay. Because otherwise it would have been exactly like that, and we would have been confused at the time of the final exam. Okay, so we were gonna look at A.
It wasn't Washington.
Okay, is everybody okay? So same, okay, all right. So let's go, okay, so in April 2020, oh, I had done this. Okay. On April 13, 2011, Watson illegally crossed, see? Crossed the Central Barrier while traveling on a busy main street. A few blocks later, he was involved in an auto accident and arrested for DUI. Mabel, the other driver, visiting from another state, had physical injuries and damages to her car, initially estimated at $3,000, but was later determined to be somewhere in the area of $12,000. This estimate did not include her medical bills and the loss of pay in the amount of nearly $69,000. She did a good job. Okay, Mabel files her suit in a federal district court in Idaho, where she resides. She files on January 5, 2012. She's been attempting to obtain a current address for Watson and has not yet served him. There's a pending criminal case for Watson's DUI. So I'm missing something here. Busy Main Street, where are we gonna make this?
Idaho?
All right. Okay. So issues. Oh, and let me qualify this. When I say issues, it doesn't necessarily mean that something that's wrong. You're just looking for legal principles, okay?
Okay. So Watson illegally crossing the center barrier, he had a duty of care to all of them. And all that.
Okay, so what are we gonna call that? Yeah.
Yeah. So do we need to list the elements of negligence then, or just negligence
So
itself?
the legal principle that governs the issue, specific facts. So you're gonna have to tie it together, okay?
Okay.
So negligence. Negligence is
Duty of care.
blah, 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 blah.
Yeah.
Here, so-and-so breached, da, da, da. You with me?
Yeah.
And now we flushed out that issue.
Okay.
That make sense?
Okay, got it.
Two, just like this, you're gonna be in and out. You're just gonna read the fact pattern. What are the issues? Okay?
Yeah.
Gotcha.
Negligence. Negligence is defined as a duty of care, breach of duty, proximate cause, injuries, whatever, damages, right?
Yeah.
In this instance, so-and-so due to care when he drove along the road intoxicated.
Okay, and then we have a jurisdictional issue, right?
Yeah, hopefully we have,
Yeah, we
this
do
better
have
have 5
jurisdictional
issues in
issue,
here, or
yeah.
we're gonna have to fix this, okay?
Yeah.
So negligence is one. But here's the thing though, you're writing incomplete sentences, but you're very specific. So when you do your final exam, I'm gonna go bam, 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 negligence, blah, 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 blah. It doesn't have to be in this precise order, but that's how clearly identified and articulated your issues are gonna be.
Okay.
Okay.
Do you want to make it a paragraph or can we bullet it for the negligence?
She said incomplete sentences, so.
Okay, never mind.
Yeah, so complete sentence, and here's the thing. When you write what I'm saying, rather than a bullet, I think it'll help you if you go 1, because you got 5 issues.
Yes.
1, negligence, 2, whatever, 3, whatever.
Okay.
With me?
Yeah.
I ain't count no bullets.
Uh,
I'm messing with you, Chris. Okay, so what's the second issue?
Jurisdiction.
Jurisdiction.
Yeah.
What kind of jurisdiction?
Um,
Oh, okay, diversity jurisdiction. Okay.
Diversity jurisdiction.
All right, bam. What are we gonna say? Diversity jurisdiction. You're not gonna do what I just did. Okay. Diversity jurisdiction requires
States live in a different part, state, or the
Parties
parties.
who live in
different state and the non-controversy B or C. Right. In this instance, is there diversity jurisdiction?
Yes.
12,000.
Why is there diversity jurisdiction?
69,000.
Different areas.
Where does he live?
He lives in Idaho, right?
Where does he live?
Oh, did I not?
He lives in
Washington. Wait,
No, he lives in Washington.
where am I seeing Washington?
Abel, well, she lives in Idaho.
Am I just?
This is visiting from another state.
Yeah, visiting from another state.
Idaho,
Watson
Main
has
Street.
not.
And then they had, her
Shoot,
car was
shoot.
12,000 and medical bills at 69,000.
Yeah.
Doesn't even say where he
From
lives.
another state.
It does say from another
So we don't
state.
exactly. That's all we need.
I'm not crazy.
Yeah.
Is
We
that
don't know
okay?
where he lives, but we know she was visiting from another state, so.
12.
So diversity
Says
jurisdiction.
Did not include the medical bills, so 12 plus 69.
12 was her first, was her
Do we
initial
meet the
estimate.
threshold?
Yes.
Yeah.
So how much we have? Because we have to have 75, right?
Yes.
75
So we got
grand?
69 and we got this right
12,
here.
yep.
Yes.
Are we there?
Yes.
Yes.
Okay, yeah.
Yep.
So you're good. Okay, what else? So we got the, so is everybody clear how we got
We
this?
have a
We're
criminal
okay
case for Watson's DUI.
with that? Okay.
Does she count that?
That's the thing, she filed.
There's a pending criminal case for Watson's DUI. There is.
All right, so I'm gonna get to him. Okay, so he says we have a criminal
Yeah, we have a criminal case, yes.
DUI. What are we gonna say about that one? Now here's the thing. Achoo. Achoo.
Really?
It's not there. It's coming. Okay. So your issue should be focused on civil procedure, right? But nonetheless, this is an issue in the case.
Yes.
So how, and we. I'm sorry, I'm looking at this. This is not going.
Look at your light.
Woo. Okay. All right. So what can we say about the DUI?
Don't sneeze, don't do it. No, not to.
It's a pending.
Pending criminal charges.
Pending.
What can you say about this?
Well, it's pending.
What have you? So this is civil procedure, but what have you learned about this? About the DUI? What have you learned based upon this right here?
That it would be considered under district or.
You learned the jurisdiction of
Yeah.
it. So you can say the criminal DUI is the DUI could be a criminal offense,
Yeah.
right? That would fall under the jurisdiction of a muni or district court.
Yeah.
Do you follow me?
Yeah.
So it doesn't have. So remember, you're not looking for something you have to make into. You just sort of issues by any particular legal issues or concepts that you've learned about in the class. They should focus on civil procedure. But yet, nonetheless, if you were to identify that and say, okay, that's a valid issue.
So, yeah, that
Okay.
it would fall under the jurisdiction of the district court. Okay.
Muni or district court.
Municipal or district, okay.
Okay. All right.
Would be, oh, what did I?
Okay. What's another issue?
Personal injury?
Service.
Service, okay.
Service.
So, notice of.
So service of what? Service of what?
Of the complaint.
So what do we have to do here?
Find that.
Once she files it, isn't it like the clock's ticking now?
Yes, very good, good, good,
What did
good,
she say?
The
good.
clock's ticking. Once she
Yeah,
files
yes,
it,
that's
it's
true,
like-
yeah. File clock's ticking.
Huh?
You better make sure you have the
That's right.
address
So
before
what?
you.
So what's that issue here then?
Due process service.
Yeah. So we got a couple. Actually, we have a couple of issues around this service thing, right?
Yeah, there is.
So one, we have is due process rights to notice and opportunity to be heard, right?
Yes.
Yeah.
The other thing is that what happens in terms of our there's a rule that comes into play here. So we can do when we do first do our lawsuit, we can either file or we can serve first, right?
Mhm.
And then that tentatively tolls the statute of limitations, but we have to complete the process within 21 days.
20 days. or something?
20 days, 14 days, 30 days,
I think it's
45
20
days,
days.
60 days. I'm just throwing some numbers
What
out.
is it?
95 days,
30 days.
90 days,
90
remember?
days, that's right, yeah, it is 90
Remember that
days.
90-day rule?
90
For
days is
service of
outside
complaints.
What now?
I thought it was only 90 days outside of complaints.
So go back and look at
That's
our
right, too.
go back and look at our original
Remember we
rule
looked it up that
when
one
we
time?
started out when we talked about
Remember,
filing our
we
lawsuit.
looked it up and we did it wrong. Service of service, like 249.
So we'd actually make this. So we actually make this be more specific here. We say 90-day rule, and then we identify the issue related to that.
It's never been commenced.
That's right. So what's our 90-day rule, Tiffany? What are we doing? What are we doing with that? What's the language that relates to this?
It says if plaintiff files first, plaintiff must serve at least one named defendant within 90 days or action treated as never filed.
That's
If
right.
plaintiff files serves first without filing, plaintiff must file the action within 90 days or action treated as never filed.
Yeah.
RCW 4.16. CR3.
Okay. So we have our 90-day rule issue there.
Yep.
All right. What's our other issue?
She's in another state, so.
Pending criminal case? Is that already?
Yeah. Let's focus on our civil issues.
Yeah.
And we kind of got the criminal case there. What about our so
The
I want you
lawsuit,
to
like,
Yeah, jurisdiction. No, we didn't do jurisdictional
Oh,
issues, did we? Yeah, we did diversity of jurisdiction, yeah.
Diversity of jurisdiction
Yeah.
and the criminal.
You got the
think
criminal.
about something as basic as your complaint itself, right?
Yeah,
Where would we have to put this information here? We wouldn't specify this, right? But what are we talking about here? Remember when you did your complaints?
oh, yeah.
And some of you had you had special damages,
Yeah.
right? You had your wherefore clause, whatever. So could you talk about complaint? The substance of your complaint?
Mhm.
And talk about how the substance of the complaint would have to include or could typically include our prayer for
Prayer for
well, it's
relief.
always going to include our prayer for
Yeah.
relief, but our pleading for special damages,
Wait for special damage.
compensatory damages.
So that would be under a pleading.
So you could talk about that.
Yeah.
Let's see here.
What is-
What about, so we got the idea of diversity jurisdiction for federal court, right?
Mhm.
But, can we also bring this in state court?
Yes.
So you have a state court jurisdiction?
Mhm.
Okay, we can establish that. Let's see. What about this issue right here? Attempted to contain a current address. What does that summons and complaint language say about doing due diligence to locate the last known address for the person? So we have an issue there.
Mhm. I don't remember.
Everybody okay
We
with this?
have to,
Publication.
yeah, like put it in the newspaper or.
And timeline, and you can't do that when you have to prove that you've been able to even try and talking.
Right, so service efforts. So we say best practices, due process requires notice and opportunity to be
Service
heard,
of,
right?
yeah.
Best practice is personal service.
Personal service.
However, substitute service could be mailing or by publication,
Yeah.
and the person has to show due diligence. With me?
Yeah.
So those are 6 potential issues from that. Okay.
Oh, we just need to do.
We just need to 5.
You just need to 5. Okay. I will come back to this.
Okay, I have a question.
Yes.
The 90-day rule,
Yes.
is it like when you file, you still have 90 days to serve the person?
They have 90 days to respond, right?
No. So remember, so as soon as and this is why it can seem to get a little bit tricky here. You don't have 90 days to respond. How many days do you have to respond?
20.
You have 20.
Oh, right.
Okay.
That's like,
All this is so think about it in terms of like this timeline right here. So screen control, no, close, projector control. We want to new video. So here's our let's say what's today's date?
Today's the 10th.
11/10. Okay. So let's say this is our timeline. We file here. Okay. We file within 90 days. So what's that? December, January. Is it February?
Yeah.
yeah.
Okay. So if we've only filed, then we better serve by this time frame.
Oh, so
Okay.
Okay. Now, ideally, we're going to do both at the same time. In some instances, we might want to serve first because we want to maybe try to negotiate. Right? Maybe we file and we're still trying to locate the person for service. Okay. So no matter what, though, once I get it, once that affidavit of service has been filed, right? Within that time frame, I now have how many days to do my response? 20.
20 days to respond.
Okay.
After it's been filed.
So don't get confused between these time frames here.
So, okay. So 20 days after they receive.
After they receive
So
the
after
complaint.
I receive it, so here's the thing. I can receive it within the 90-day period. Who cares, right?
Yeah.
But I better receive it within this period. You follow me? The bottom line is that once I get it, once I get your complaint, I then have 20 days to file my response. I don't have 90 days.
Okay.
Okay? Now if I'm out of the jurisdiction, I have what?
Yeah.
The 60-day
60
period.
days, that's right, yeah.
That's what
Yeah, 60 days. If you're out of the jurisdiction, right? What is considered